Chief Justice Rabner, honorable justices of the Supreme Court, Judge Grant, and members of the judiciary, as well as our other honored guests. My name is Kate Reilly, and I have the honor to stand before you today as president of the New Jersey Association for Justice. The more than 2,700 members of the New Jersey Association for Justice are trial lawyers who have extensive experience practicing in the courts of New Jersey and are well-versed in the issues surrounding jury selection. Thank you to Justice Rabner and to the Associate Justice of the Supreme Court, as well as the AOC, for calling this conference. Let me be clear from the outset. The use of challenges, be they peremptory or for cause, in a discriminatory fashion is offensive, unethical, and illegal. Our association applauds and supports efforts to remove discrimination in the selection of juries in our criminal and civil courts. Peremptory challenges, however, are not the problem, and it would be a mistake to reduce or eliminate the number of statutorily afforded peremptory challenges. As a female trial attorney who has regularly represented minority clients for almost 40 years, I have seen the effect of discrimination against me and my clients by jurors, adversaries, and judges. The disregard based on race, ethnicity, alienage, and/or sex is most often implicitly conveyed by a look or demeanor that rarely gets put into words. The idea that I would not be able to exercise peremptory challenges to protect my clients from such biases would serve to magnify bias and discrimination in the jury selection process. Regardless of what research may show in other states, Dr. Rose in her report found that peremptory challenges are rarely the primary way that minority groups experience attrition from jury participation. Fundamentally, the issue with discrimination in jury selection arises at the beginning of the process, not the end when peremptories are exercised, as Dr. Rose's research reveals that New Jersey fails to effectively summon a representative cross-section of the community to the courthouse to serve as jurors. Dr. Rose found that the attrition most greatly affects African Americans. Dr. Rose's research indicates that we must expand the sources for the master juror list, as is proposed in Assembly Bill A 4275. We should consider allowing those with convictions to serve after a set number of years and increase juror compensation. The New Jersey Association for Justice supports the recommendations of Dr. Rose and Professor Chernoff, which suggests that more research and data collection must be done. Dr. Rose notes that consistent with Supreme Court rulings, parties should have access to de-identified data to pursue or defend claims about the representativeness of cognizable groups in jury pools. We need the data. Importantly, in Danksel, the court directed that to better assist our courts in preventing underrepresentation, we direct the AOC to begin collecting jurors' demographic information. In order to make certain that the jury is fair and impartial, a thorough voir dire is required to probe the minds of the prospective jurors to ascertain whether they hold biases that would interfere with their ability to decide the case fairly and impartially. There is no better antiseptic to implicit or explicit discrimination in the voir dire process, assuming that a representative sample of the community makes it to the central jury room in the first place. Attorney-conducted voir dire must become the principal means of jury selection. The lawyers and parties have superior knowledge of the factual details and are better positioned than judges to understand how explicit and implicit biases of jurors may affect the outcome of the case. As noted by retired federal judge Mark Bennett, Judge-dominated voir dire may exacerbate implicit bias in the selected jury's determination because it prevents detection and removal of implicitly biased jurors. The appellate division in Cantado versus Sheraton Post Inn stated that everyone wants to be thought of as fair and open-minded, but it does not dissipate feelings of bias for the judge to suggest by his questions how unworthy of good citizenship such feelings might be. Early answers from prospective jurors may have a spontaneous accuracy that latter judicially channeled answers may lack. Unfortunately, for the sake of expediency, it has become an everyday occurrence for judges to rehabilitate jurors who have expressed bias. If the judge can rehabilitate numerous jurors, they are less likely to be excused for cause and will be impaneled faster. Expediency most certainly does not justify this practice. Dr. Rose acknowledges that prior research from outside New Jersey typically finds judges to be overly cautious about removing jurors for cause, aiming to rehabilitate people whose ability to be fair presents grave concerns to parties or other court observers. All of us have experienced judicial attempts at rehabilitation of jurors in voir dire. Moreover, such attempts are exercised differently based on race. Attempts to rehabilitate white jurors overwhelm the attempts to rehabilitate minority jurors, whom judges are more likely to excuse without an attempt at rehabilitation. If peremptory challenges were to be reduced or eliminated, it would only further compound this practice by trial judges, since as rare and uncomfortable as it is for counsel to raise a Batson or reverse Batson challenge against opposing counsel, it is unheard of to make such a challenge against the trial judge's exercise of challenges for cause. What trial attorney would not fear offending and making an enemy out of the judge in making such a challenge? Batson-Gilmore reform, rather than reducing peremptories, is the appropriate approach to remedy concerns regarding challenges that are discriminatory in nature. While Batson is widely viewed as broken, there is a fix. Both California and Washington State have reformed Batson to insert an objective rather than purposeful discrimination standard. Andujar foreshadows that New Jersey should move to such a standard by declaring that Gilmore extends to implicit bias discrimination. For-cause challenges should require a de novo review as well, since the abuse of discretion standard left to trial court judges allows implicit bias to infect the process, and the decisions are insulated from review by the abuse of discretion standard. I'd like to touch on the views espoused by Dr. Rose regarding unused peremptories and unused jurors. She suggests that most attorneys do not use their full complement of peremptory challenges, and that a certain number of jurors summoned for service are simply not used as justification for reduction of peremptory challenges. She did not study how jury clerks decided on the number of jurors to summon. This is not a basis to reduce the number of peremptories. It is a basis to reduce the number of jurors summoned for service. Dr. Rose made no effort to survey the attorneys that failed to exercise their full complement of peremptories. We simply do not know why this did not happen. Was it because they were concerned about the remaining panel, such that they did not want to use their remaining peremptory and then be left without any when a worse juror got impaneled? Did the judge intimate that there would be negative repercussions if the attorney exhausted their challenges? I've certainly experienced that over my career. I suggest that some of Dr. Rose's findings are confounders that result from her failure to control for the effect of the length of the trial on the voir dire process. Relating the absolute numbers of for-cause challenges to peremptory challenges is meaningless. Particularly in lengthy trials, challenges for cause will dwarf peremptory challenges due to more jurors being unable to commit to the length of the service. Also, the comparison of total challenges for cause versus peremptories is not even the proper comparison. The number of challenges for cause when the juror has expressed some form of bias versus peremptories used is the issue. In conclusion, the New Jersey Association for Justice supports measures to expand the pool of people who are brought to the courthouse for jury service. These include expanding the jury lists, allowing those with criminal convictions to serve, and increasing juror compensation. We also believe it's critically important to collect juror demographic data, make this data available to parties, and allow analysis of this data for study. The New Jersey Association for Justice believes it's vital to have meaningful attorney-conducted voir dire. It is a crucial component of selecting a fair and impartial jury, and distinctly lacking here in New Jersey. The New Jersey Association for Justice opposes any attempt to reduce or eliminate peremptory challenges, as such an action would not advance the goals of this conference and would only serve to magnify bias in jury selection. Thank you for the opportunity to take part in this conference on behalf of the New Jersey Association for Justice.